Good morning, Mr. Mendoza.
One time.
Sir, you're charged with two cases with us. You were charged with assault of a family member. You're now also charged with failure to identify oneself to a peace officer while being accused.
Hold up. Did you catch that? That last charge, failure to identify while being a fugitive, isn't just a paperwork issue. It upgrades the charge to a Class A misdemeanor, meaning up to a year in jail. Why? Because if you're running from the law, even lying about your name becomes a big deal.
Fugitive from justice. That allegation kicks it up to a Class A, so you're also facing a year in jail and/or a $4,000 fine. This case the assault is a year old. I have no idea what is going on with it, so I'm going to have you refresh my memory real quick. What happened, please?
On the AFM?
Please. On all three.
So on the AFM, which is the original charge, on April 6th.
This is textbook domestic violence evidence. Visible injuries, bloodied towel, corroborating witness, and a long-term dating relationship. In Texas, that elevates it to assault family member, which the courts take especially seriously.
2024, officers spoke with a complainant witness who stated she was involved in a physical altercation with the defendant after the defendant became upset with her over food and struck her several times with a closed fist in the nose and mouth, causing her pain and visible injury. Officer observed the complainant witness to have a swollen bottom lip with a small laceration, and she was holding a bloody towel that she used for her nose. Defendant was identified by his Texas driver's license, and the defendant and the complainant witness have been in a dating relationship for 8 years. So that's the oldest AFM. Do you want me to do the felony?
Yeah.
Okay.
What?
Pause. Did she say she had a protective order against him before this altercation? That means if he showed up at all, much less threw her against a wall, he could be violating that order. That's not just more charges, that's jail time stacked on jail time.
It's on the felony. On June 4th, 2024, officer responded to a disturbance call and spoke with the complaining witness. Complaining witness stated the husband threw her on the wall after she called his mom to complain of his behavior. Complaining witness said she had a protective.
Shh. I didn't hear any of that.
Officer, on June 4th, 2024, officer responded to a disturbance call and spoke with the complainant witness. Complainant witness stated that her husband threw her against the wall after she called his mom to complain of his behavior. And then she stated that she had a protective order against the defendant. And then the failed to ID. On April 11th, 2025, officer dispatched to an unknown disturbance call for service. Officers arrived on scene, knocked on the door. Officers observed a male come to the door, but quickly move out of the way, not wanting to answer the door. Officers observed the defendant walking out of the door, stating that he was only having a verbal argument with his wife.
So
Officers-
now a new fight and that's what brings the cops to the house?
I believe so.
Now this is where the judge starts losing patience. This guy's been in flight status for nearly a year, meaning he hasn't shown up to court, and now he's back in front of the same judge after yet another domestic call. Audience, be honest. How many second chances is too many?
Officer spoke to the female on scene. Officer stated the female was not answering questions due to not wanting to get the defendant in trouble. Officer observed the name and date of birth the defendant provided to officers were not coming through a TCIC search. Officers advised the defendant that if he does not have proper name and date of birth, he'll be charged with failure to identify. The defendant then confessed and provided his real name and date of birth. The defendant stated he did not want to go to jail for a warrant that he had. And then the officer observed that he had a felony and misdemeanor warrant.
The reason you speak English, right?
Yes, sir.
The reason I'm trying to figure what's going on is because she's asking me to give you a PR bond, but
Yeah.
we've given you bond after bond after bond. You've been in flight status for about nearly a year. And now when the cops come to try to talk to you, you try to evade again. You know what I mean? Are we just going to continue to give you chance after chance? You continue to you just don't give a shice about bond conditions, man. Really? I mean, I get it that he may have not signed it or whatnot, but you can't just be out of sight, out of mind for an entire year and expect good things to happen. I mean, really, we've given you PR bond after PR bond. It would just, at some point, I have to say when, so that we mean business. There's no more revolving doors, really.
The original AFM, it looks like they did do a written call The complainant advised that the reason that she had a bloody nose is because she does drugs and was doing cocaine.
Here's the real warning shot. The judge just invoked no bond status, one of the few constitutional ways to keep someone locked up pre-trial in Texas. Translation: if he violates again, he's not getting out. At all.
He did have the PR bond. The VPO was a 2V warrant, so he wasn't given bond and didn't come on that one.
Yeah, but he had warrants out for both. Apparently knew about them. So I'm
Well,
not.
it didn't say that he knew about the felony warrant,
Well, I don't know,
He had
but
a warrant out.
but you can't make believe that he knew.
I mean, I can, if you want a bond reduction, I'm willing to give you a bond reduction. I'm not gonna give you another PR bond, dude. Really, I'm just, no more PR bonds. And you know, you've got these cases out. Just, you can't out of sight, out of mind. And the only reason you're here now is because you got into another damn argument. So, Mr. Mendoza, I am now issuing another protective order on this case. And I want you to understand that the Texas Constitution does not allow me, but
That 200-foot restriction is no joke. If he so much as walks by her workplace or home, it's another violation. And remember, pre-trial is watching, random drug tests, weapons ban, and a strict MOA. Think he'll follow it this time?
in extremely limited circumstances to have a hearing to hold someone at zero bond. This is now one of those cases. If you continue to violate protective orders, we can have a hearing to hold you at no bond. Do you understand? I don't want you to have contact with this person. No means no. Doesn't mean, please, baby, get me out of jail. Every phone call is recorded. Take note when you're making phone calls. Every phone call is recorded. Do you understand?
Yes, sir.
I'm not asking for much. All I want are my streets to be safe. And if you can,
Yes, sir.
just don't have any contact, don't have any weapons, and that's it.
Sir.
If you want a bond reduction, I'm happy to give it to you, but I'm not going to just continue to give homeboy PR bond after PR bond after PR bond. Just not, you know?
Would the court be willing to reduce the bonds for $1,000?
I'll cut it in half. So on the assault, 2,500. I'm going to leave the failure to ID as is. But I'm telling you now, I don't know if you're going to get out, but if you do, there is a residential restriction. You cannot go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
No alcohol, no illegal drugs. You will be randomly tested. No contact and no weapons. Do you mind? All I need you to do is file the MOA because we'll have him, pre-trial is going to, make sure that you're in compliance. All right, Mr. Mendoza. So what we'll do is the felony case is set for June. So what we'll do is, I don't like to set the people for more than 30 days, so you just don't get forgotten about. Well, we can set you for 30 days, come back, and then, go from there. Okay? All right.
Maybe.
Yes, ma'am. Thanks.